Welcome to the latest update in the Noah Presgrove case. Once again, we're looking at new court documents and responses from differing people, from the court to the plaintiff's response to defendants, etc. Be sure to stick around today for the full understanding, and we're going to break it down bit by bit. We'll be looking at two sets of court document papers. First of all, in regard to that original subpoena, what the estate, the family of Noah Presgrove wanted when it came to either OSBI or OHP, their investigative approach, materials that they gathered over time in the case, where things are now at. Whilst one side may be satisfied, the family aren't, the plaintiffs aren't. So they wanted that subpoena in the past. I think it happened around the time of when you had that wrongful death lawsuit, that petition. Well, not petition, the actual following through with it. And then the defendants' names came about. Avery, Carter, Logan, Jack, Caleb, Val Patrol, Jane John Doe, and Johnny Trout Wilcoxon, and Stevie Howard, and if there's any other names I've missed out. So there was quite a bit of movement, legal movement in the past some months ago. And over time, it's been working in the background. And that subpoena did happen around the time of the wrongful death lawsuit onwards. And there's been a bit of either a delay or at least a wall of silence to the general public. But now there appears to finally be a response, as in the situation. Because in between, there was resistance from OSBI that wanted to counter it. They didn't like the idea of the subpoena. I guess they didn't want material investigative evidence to be handed over or shared about, such as to the family, the estate of Noah Presgrove. So with that counter resistance, slowing some of the movement down, adding a bit of tension and possible frustration to the family, the victim's family. But now the courts responded, and we're going to be looking at that today. Check the details within, what's being analysed, what's being considered, what's being reviewed, and how does it affect and impact the case going forwards. And the second of all, we're going to take a look at the plaintiff's response to certain defendants that want or have wanted to be dismissed from the case, I guess because they strongly believe that they're not associated. But I don't think Caleb's name is mentioned as one of the defendants wanting to be dismissed. And you would think, in fairness, out of all the defendants that have been named and responsibilities applied to them linking to Noah's death, Caleb would be the one you would expect to want to be dismissed, because the role that they supposedly play in the case and the death of Noah is a little bit obscure and odd, because on the looks of it, Caleb, from what's been said over time and the lack of hard evidence publicly, Caleb Newton, Jack's father, was never at the party physically and supposedly didn't own, or it wasn't in his name to do with the side-by-side. It was Jack's side-by-side, and Noah used it. Whether Jack had the chance to give Noah permission or not, any responsibility should fall on top of other responsibilities on Jack's hand and not Caleb. So was it a desperate attempt to drag Caleb into all this? I mean, there are other roles and areas which Caleb plays, fair enough, but how it's applied to Caleb in the case, it's not mentioned, just details which don't quite make sense or link. But other defendants' names that wanted to be dismissed, whilst officially it's not reached a verdict, like by court, not yet. You know, the people that are wanting to be dismissed, and you probably see the names as well in the documents, you're going to be shocked by it, surprised. I'm going to give you my raw reactions and response as we go throughout. We'll look at the first piece of document, read, and then conclude or reach a bit of a summary, and then move on to the next. And then if there's time at the end, I'll catch up with some comments from a previous video that I did on the case. So there's a handful of stuff to get through today. Possible progress being made, movement definitely, and we'll see what happens next. Welcome if you are currently here in this live premiere. Share your thoughts, reactions in the live chat box on the right side of the screen. And at any point or time, And for those watching on catch up, if you have any questions, answers, thoughts, theories, reactions, be sure to drop a comment below under the video, as it will help with spreading awareness, starting new discussions, etc. And if you would like to support the channel, in the comment section, there is a pinned message with links to follow through with. Now, if you want to catch up on the recent videos of mine, from the Noah Presgrove case to Kenny Veach, some shocking developments there, and for the full playlist of Noah Presgrove coverage, that will all be available top right corner where the I symbol is up there. So, without further ado, let's begin. As it reads in the District Court of Stephens County, State of Oklahoma, the estate of Noah Nichols, Noah Presgrove's family plaintiff, v. Avery Howard as an individual, and others. Notice of decision. I'll zoom in just to make it a little bit clearer for you to see. On the 9th day of January 2026, the above captioned case was set for hearing as to the OSBI's objection and motion to quash the plaintiff's subpoena. I believe OSBI stands for Oklahoma State Bureau of Investigations, I believe. We've also got OHP, Oklahoma Highway Patrol, that attended first on scene at the time of Noah Presgrove's death unfolding. Let's continue reading. After hearing the argument from the attorneys for the plaintiff and the OSBI, the court ordered the OSBI investigative file be supplied by agreement in its entirety to the court for an in-camera review. See court minute filed the same date, with certain orders to follow as the court deemed appropriate. After having now conducted said in-camera review, the court makes the following pronouncements. Administrative findings. The court has reviewed the entire file provided to it by the OSBI concerning its investigation into the death of Noah Presgrove. Specifically, the court reviewed the following documents and files. This gives just like a tiny heads up as to, what to expect for the evidence and material collected from the beginning of the case unfolding. A, documents labelled and, did that say Bates? Or did they mean to say dates? Probably Bates. Stamped OSBI through OSBI. B, 4 electronic subfolders and files contained in an electronic folder labelled Analytic Case Support. These electronic folders, like interviews, audio, videos, possibly photos within the files by the scene, partygoers, responses, witness reports maybe. C, 1 electronic folder labelled autopsy. Right. So that electronic folder of the autopsy, is that going to include actual real photos of Noah's body when the autopsy is being done? And maybe more so photos and documents in more detail. Like the autopsy, what we saw, which was revealed public, as in text and words only. This electronic folder may contain additional material which wasn't revealed in the public autopsy report, possibly. For those watching right now, do you think that the autopsy, the public papers that were revealed, does that give every detail, or do you still feel that there are hidden things which are probably held back but could well be, such as on here, C, 1 electronic folder. D, 1 electronic folder labelled Biology Report, OHP case, probably to do the scene and Noah's body. E, electronic folder containing 9 audio files. Those 9 audio files, the defendants, the partygoers, when they were talking to police at some point, like Caden Pressey did, an audio recording of an interview. That'd be interesting. Labelled OSBI interviews. There we go. F, 11 electronic subfolders contained in electronic folder labelled OSBI Receipts Chain of Custody. G. Photographs electronically labelled DSC through to DSC, and right, those photographs really of anything, I guess, probably the scene, Noah, and some of the people. H. One electronic folder labelled Prosecutorial Report 2. I. One electronic subfolder contained an electronic folder labelled Surveillance Video. Now, what does that mean exactly? Because when I think of surveillance, footage of surveillance, like CCTV, and there was no CCTV on the highway, but there were cameras on site of the party house, the property, but they weren't working supposedly, unless the surveillance video could well be by authorities, OHP, when they showed up, if they had those cameras on them, front cameras on the chest area, which they used to document the investigation in the moment and for their own personal safety protection, in case anyone nearby was volatile or attacked. You got it on camera, you got it on record, so you could use that if you needed to protect yourself, maybe for evidence. But yeah, surveillance, the only thing would be the party house, and that supposedly wasn't working. J. An electronic file labelled attachment list and an electronic file labelled property and evidence list. So it is a bit divided by people, as in, was the party house property searched, yes or no? Beside the scene, the highway, what about the party house? Graphic people in the early days have said it wasn't searched, it should have been, wasted opportunity, wasted evidence, it's corrupt, the police are corrupt, they're being paid off. But as it's worded here, that there is a form of evidence, and it's to do with the property. And when they say property, do they really mean the party house property, or property as in a possessive term to Noah, items of evidence like clothing, artifacts? Could mean one of two or many things, possibly. And the evidence list, to be honest, in regard to Noah, the chain or pieces of a chain, one shoe of his at least, and then the white shorts which he borrowed in the middle of the road. As for other items of Noah, evidence, possessions, golf clubs, wallet, supposedly the hat, the other shoe of Noah, the top, missing. Where did they end up exactly? Strange. So would you say the findings, the investigative material and evidence, if that's everything and the court has looked into it and reviewed, would you say it's rich? Would you say there's a lot there? I mean, some of the numbers given seems low, but these folders could contain a lot, because with the Dylan Rounds case, when the case was solved and onwards, and after that it was released public to some extent, there was like thousands of photos and videos. It was quite overwhelming. Now, it felt pointless by then because the case was already done and dusted, and I already covered the case, so there was no point looking back at it. So that's the only downside. But there was a lot there. There could well be a lot here too. And to be honest, with more people being involved in this case, and the length of time it's taken to interview people to get through people, I'm sure there's going to be even more. Because in the Dylan Rounds case, it was only like 2 or 3 people, and mainly just one focused, the killer. But in this situation, there's a handful of defendants, a lot more than Dylan Rounds. So what's this? Findings of fact. I'll zoom in just a little bit there. Under questioning by the court during the January 9th hearing, counsel for the OSBI gave the following answers that the court finds valuable for consideration. A. That the OSBI will under no circumstance waive a privilege to its documents being disclosed for any civil purpose. B. That the OSBI cannot point to any language entitled, and that divest courts of authority to order disclosure of documents or files. C, that the OSBI contends that Title 74 creates an absolute privilege as to the disclosure of its records not subject to judicial balancing. And D, the OSBI admits that the investigation into the death of Noah Presgrove has been closed. The OSBI agrees that any release of these records can cause no harm to the investigation due to the fact that it is no longer active nor open. Interesting. You know, when people have gone over there and read it, investigation, I think Tim Daniel and some other people saying it basically means the case is closed, the case overall. But to my knowledge, an investigation is its own thing within the bigger picture, the case. An investigation is the beginning. So we can have a little discussion about that once we finish with these documents and just see where people are really at. OSBI admits that Noah Presgrove's investigation has been closed. Also agrees that if any of the records are released, it will not cause any harm. When it says, agrees the release of these records, I'm guessing that's separate to the investigative evidence within the case. Because they said if the evidence was to be released, it would cause no harm, then it wouldn't make any sense as to why they've countered the subpoena. So they must be talking about separate stuff here to the evidence in the case. As I said, first time looking at this. But it's interesting how it says the investigation, because of the fact it's no longer active and it's not open to. But at this moment in time, that's how it is. But could it reopen in the future? We'll see. E, that the OSBI will not distinguish between fact-based files and files containing investigator work, product strategies or theories when deciding to withhold items as confidential. The OSBI instead claims to withhold the entirety of the file. F, the OSBI cannot articulate any harm that would come to its agency by agreeing to disclosure of the documents sought in this case, except for perhaps some additional labour involved by their agency should this case lead to more subpoenas of their records in the future in other civil cases. The OSBI admits it's objecting to the file being disclosed solely on a policy basis. Right. The OSBI agrees that there is no other mechanism that plaintiff could utilise to obtain these documents and files. Subpoenaing, I say that, a subpoena, we'll put it that way because I can't word it the other way. These documents and files from the OSBI is the only method by which the plaintiff could hope to acquire this information. H, OSBI agrees that courts are not bound by opinions issued by the Oklahoma Attorney General's office. And I, the OSBI agrees that this case is a case of first impression in that OSBI records are being sought in a civil case after the Oklahoma Supreme Court issued its ruling in McKesson versus Campbell. Right, is that like an example of another case? Just anything else I need to acknowledge back here? The OSBI admits it is objecting to the file being disclosed based on policy. So when they say file, are they talking about the whole evidence in the case, what the family want to be given and shown? And OSBI shown resistance simply because of policy, and that's it, nothing else. Because if it could be interpreted in any other way, yes, you could argue, why does OSBI want to hold it away from the victim's family? Shouldn't they get some form of closure, second opinion in a way? Is there any resistance because there's corruption, as what other people in the community would try and push? Let's now look at the conclusion of law. Zoom in just a little bit. 3. The court finds that the arguments presented by the plaintiff in its response to the OSBI's motion to quash well-founded and hereby adopts them in its decision. The court does not find the OSBI's position that it is merely relying on policies as the basis for its objection to the disclosure are these files to be persuasive. So basically, just because of policies, it's not good enough of a reason to counter the subpoena, and the court acknowledges that. Furthermore, the court finds that Hicks' case, which is the crux of the OSBI's motion to quash, has been undermined to some extent by the Oklahoma Supreme Court's decision in McKesson. The court agrees with the OSBI's admission that the McKesson case has put the OSBI into a matter of first impression now with regards to records request of their investigative confidential files. 4. The court finds that appropriate safeguards and a protective order can be put in place to preserve the integrity of any records or files which could be ordered to be made available to attorneys in this litigation. The argument that these records should be made available to attorneys in this litigation is further strengthened by the fact that the OSBI has closed this investigation and the case is not active. Right, that's important that. The investigation process and part has come to an end, has closed. The case is not active. But the case, well, that's the thing. Is there a difference between a case being closed and a case just simply not being active at this moment? I can understand how you could put it across that the case is also closed, but if the case is truly closed, then it would mean it's kind of reached a true conclusion and there's been justice and people are being charged, there's been punishments given out, or it's been completely cleared, the defendants, and it's like it's all done and over with. The case is currently not active, but it doesn't mean to say it's closed. It could be reactivated if the investigation opens up again, if there's a strong enough reason to do so. That's how I interpret it, but yeah, definitely got to look at the wording, of course, and be careful with it. 5. In reviewing the files designated and above, the court took care to look specifically for the following items which would have been proper for redaction should the court order the files disclosed. A. Law enforcement work products such as strategies and or deliberations. B. Potential charging decisions or discussions with prosecutors concerning the same. 6. With one minor exception, the court has determined that the entirety of the files produced to it by the OSBI are very fact-based files that reflect the actual factual evidence in the investigation into the death of Noah Presgrove. So, from the looks of it, all the evidence material collected by OSBI in the investigation is very fact-based. So whatever it means, and if it comes to a conclusion with Noah's death, then it's supposedly an absolute fact and that's it. So maybe the OSBI, in their minds, believe it to not be foul play, for it to not be murder. But, depends if enough evidence has been collected. You could get enough fact-based material and files which can reflect factual evidence within the investigation, and it points in a certain direction within the case and not suspicious, not dark. But there could be other evidence still out there somehow to collect, which then could point in the opposite direction of murder or foul play. If it's not been collected yet, it's not known of. But will it ever open up again the investigation, I wonder? There is virtually nothing that the court would consider work product and or prosecutorial analysis contained in these files. The only exception to this being that one section of one document should be redacted before being made available to the attorneys for review, specifically Bates' stamped document, beginning at word 4 and continuing through the remainder of 2. This same redaction should also be made on this same document which was produced in duplication. Okay. Wherefore, the court orders the following: the OSBI's objection and motion to quash the plaintiff's subpoena is hereby denied. So what Noah Presgrove's family wanted for that evidence and material to be handed over or shared over so they could see it for themselves in a way, originally OSBI countered it and rejected, almost showed resistance, but the court has come to a conclusion. The court feels that what the OSBI wants, nope, denied. So it seems like the subpoena will follow through from the looks of it. And to finish off here, let's just see. Counsel for the plaintiffs and the OSBI shall present an agreed upon protective order to the court for approval as to this specific OSBI investigative file. This protective order shall include language explicitly limiting the dissemination of these files to only the attorneys who have entered an appearance in this case. Right, so does that mean that Noah's family won't directly get first-hand looks into this material, but the attorneys of the estate of Noah will, and then pass it on to the family? But will they not see it first-hand? I wonder. Beside that, necessary staff and who assist the attorney in this litigation or any proposed expert witnesses who require viewing the file as part of their services. These records shall not be made generally available to other attorneys or staff who also work in the law office who are not specifically assigned or who has not entered an appearance to this litigation. Furthermore, the records shall not be made available to any of the parties and are being restricted to the aforementioned attorneys, staff, and potential expert witnesses at this time. This restriction may be reviewed and reconsidered the closer this case gets to trial. Interesting. Lastly, each attorney, staff member, or expert witness who is going to view or work with these records shall sign an affidavit, which form shall be attached as an exhibit to proposed protective order, attesting that they will not divulge or disseminate these records to any other person who has not likewise also signed said affidavit. These affidavits will be filed with the Stephens County Court Clerk's Office and will be made part of this litigation's court file. Violations of this protective order will be enforced through the court's indirect contempt powers as well as any other remedy available. And lastly, the OSBI shall make available to each attorney who has entered an appearance in this litigation a copy of the same flash drive, the most recent one. It provided to this court for in-camera review purposes. Only one flash drive need be made per law office should more than one attorney have entered an appearance from said office. OSBI shall make this flash drive available to a requesting attorney within 30 days of said request. Okay. And counsel for plaintiffs and the OSBI shall prepare a formal order for the court to approve that is substantially in compliance with the terms contained herein. So ordered. After looking at those documents, it basically appears that the OSBI didn't get what they wanted, but possibly the victim's family, the estate of Noah Presgrove, did get what they wanted or will be granted it at some point. Correct me if I'm wrong, but that's how I interpret the situation. The only slight negative, and it depends on how the general public interprets it, is about the investigation closing, reaching an end point, and that the case being deemed as inactive or not active. Now, I think Tim Daniel, just one individual, there'll be others as well. I'm just basing it off memory. And when I had a brief look at the comments section, I think Tim Daniel was highlighting or suggesting that the case is closed. So then that must mean that whatever's being collected is more than enough, and that there's not enough or there's nothing to suggest murder or foul play. So it is just an unfortunate accident, and that linking on with defendants, they're not responsible either, or shouldn't be to some extent. But, you know, interpretation with language and wording is very important. So let me just adjust that. There we go. I want to know what you think about the documents, what you read or listened to yourself just then. Do you believe it that the case is truly closed? I'm going to give you my thoughts with the supposed reality of the situation, okay? Because I do look at language and wording a lot, the definition behind it and what it really means. So when it comes to the OSBI, no mention of the OHP, but OHP has played a major role in the case too, as in being active on scene at the time and with what they witnessed and saw. A collaborative effort, you could put it, but more so OSBI. The investigation has closed, or reached an end. The thing is, investigating, it's a process, and it happens at a certain point. But it can also reoccur in the future if need be. So it's not the complete end, technically speaking. It is a good enough reason to open up the investigation, reopen it once again to collect more evidence because new developments have come about, or what's already been collected has been denied, dismissed, or not deemed good enough. So there needs to be more time spent to collect more. I believe that's roughly what happened in a way with the Dylan Rounds case. Evidence was collected with time. The the Box Elder County Sheriff's Office, I think that's what you call it. I can't remember the abbreviation because we're covering Presgrove, but Box Elder back then believed they did a good enough job on the case, the investigation and the material collected, but to the family, or to some, it wasn't deemed enough. So there was a bit more time, and with delays, went and collected more, and in certain ways collected more, strengthened, double-checked the material and evidence to make sure there was enough and whatnot. But in this case, the OSBI say that the investigation has been closed and are satisfied from the looks of it, with the possible outcome as well. Yet, you got, or had at the time, the autopsy report which said time of death unknown, cause of death unknown. So if all of that is unknown, but the investigation has closed, has anything occurred since which may have updated the reality of the autopsy report? Because if the autopsy report, lack of details and the vagueness remains as it was when we saw it public, if it remains like that right now, then how can the investigation be closed and people satisfied with it if things are still unknown of? That's not exactly good, but things may have changed with time. Autopsy might have been updated. See, what we saw back in 2024, maybe May, things have changed a lot since. With all that time passing by, a lot could have changed and developed in different ways, but in the background. So, it's like you're left in the dark. You don't know. Things are happening which you're not aware of. Progression could be made in some way, just not been revealed public. If that's the case, then it's understandable. But to link back to what I was getting at, the investigation is a part of the case. The case is the bigger picture. The reason why there's an investigation is because there is a case at hand. When does the case officially start? Well, I'm not an expert at the beginning, but once the death has happened and formal contact has been made with authorities and it's been processed, then the case opens up. An active case of a homicide, an active case of something. I'm just giving you an example there, how it can open up. I think it's once contact's made with police, dispatch, services, authority, it's all been processed and acknowledged that something bad has happened. It's now time to investigate and work out what's going on. And in some way, you could say the investigation started the moment, roughly, when Tyler Hoodman at 5:43 made that call and Tyler Hardy at 5:53. And then OHP came on down, and then others, and then the ME medical examiner came on down eventually after delaying stuff, which you could question, because they went elsewhere to Lawton to do something else when they should have been down at the highway as soon as possible, from what was said. The liver mortars kicked in, and it may have not done if the ME got down there quicker and action was taken faster, possibly. But, investigating the body, checking collecting evidence and possessions which are on the scene and nearby, like the necklace chain, the teeth or tooth, Noah's shoe, the mismatched one, bits like that, and the hair on the buttocks or near to the body, and the odd little pool of blood collecting all that. And then moving on over days, interviews, and whatever order it was done in, the investigation process as part of the case, the investigation in trying to gather material and evidence to make sense of what's happened, to see if anyone is responsible, and then to find the evidence that could support that or go against it for the sake of the case. So then when enough is collected, of satisfactory nature, the investigation process, the collection of evidence process can come to a close, an end, and then it's the next process moving on. The case still ongoing in a way, and then moving on to the next process, to the next one, to the next one. I don't mean to say that the case is closed. If the case was closed, well, then obviously the investigation would have ended before that, and then the case being the end thing to close. It's the overall thing, the case, as in justice being served, anyone responsible being dealt with, consequences, punishments handed out, and reaching a conclusion. But the only mention that it's said in regard to the case is inactive, not closed. Now, there's a difference between being inactive or not active versus closed. Closed mean that's it, done, it's over, no going back, in a way. If a case becomes inactive or not active, same thing. It can also mean it's paused, on hold. And that could apply to anything really in life. When things feel inactive, when things feel like it's not going anywhere, or at least it might feel like that. There's nothing new happening. Maybe it feels like you're left in the dark, or you've hit a bit of a brick wall, not sure what to expect next, not sure what's going to happen next. It can be a period of silence. It can feel that, it can sound like that. A period of silence for yourself, for others, the unknown, the uncertainty. But during that pause, time for reflection, time for other processes going on in your hands or in other people's. And then if there is some kind of conclusion, if there's some kind of movement going on silently, which you're not aware of, then it might become active once again. It means it's not the end. Whatever it is in life, it's not the end. There is still unfinished business. There is still things that could be going on in the background right now, and more likely there are things that will happen onwards at a later point. But at this moment, it's just on hold. It's not game over, just on hold for now. So, look, if you search it online, if you was to use like the AI, it gives its reasons and explanations, saying when a case is inactive or not active, it doesn't mean it's closed. It's just on pause, whilst other things are being sorted or maybe processed in the background, pending, right? So, yeah, the way I see it, the case hasn't been closed. It will only be closed once there's a true conclusion and justice in whatever format has finally been served. It's not even got to that point yet. How can the case be truly closed if the defendants and anyone else haven't even reached the court period of, the discovery process, and then the, appearing in court and talking and speaking and all that as you'd normally expect. It's not even got to any of that yet, and people are saying the case is already closed. I know things can be thrown out if there's just no evidence whatsoever to say it's murder or these defendants are responsible. But whilst the defendants some of them may think like that, and that might be why there's that dismissal of responsibilities. We'll look at those documents shortly as in the plaintiff's reaction and response to it. Those that believe the case is closed as of right now, based on the language and wording, maybe it's best to wait to see the reactions and responses by the court, besides the plaintiff's response to certain defendants, 4 of them supposedly, that feel they should be dismissed from the case overall, and I guess a wrongful death lawsuit. If by some chance the court accepted and said, yes, they can be dismissed, then you could say there appears to be movement heading in the direction of a possible case being closed. I'd understand that, but we've just not got there yet. So there's still time. And as well, as I said, if there comes a point where there's a person of interest, there's some development, there's a breakthrough, there's an unexpected twist in the road, a turn in the future, which can happen, and based on a community basis and patterns within the case in a way online, there has been twists and turns already previously, so it could happen again, but more officially. Twists and turns where it reopens up an investigation. I mean, like, look at a missing person case and you got those missing person reports online and the police are looking into it for a certain period of time. Then when there's no more progress, or it feels like it's hit a bit of a dead end, a hard wall, they're not looking into the case anymore, it can become a cold case. It feels like it's reached an end. That's it, game over. You could say it's kind of on pause, because if in the future there was any future evidence, anyone stepped forwards, new developments, new findings, a new sighting of that missing person 5-10 years ago, the case can reopen and become active once again. And if it's got the chance and opportunity to become active, then it's not truly closed. It's just become inactive and paused, gone into hibernation over a period of months or maybe years. But then when suddenly light shines in a direction, I'm thinking of the Kenny Veach case, missing person, Las Vegas Metro Police Department, police people assigned to that case, and eventually over time either they retired or stepped away or moved on to other cases. The Kenny Veach case went cold, but it wasn't closed because there wasn't ultimately a resolve and the person was still missing, and they're still on the NAMUS database, missing person register. So it's not reached an end, it's just gone cold. Kind of like the Noah Presgrove situation for the investigation. It's gone cold, but not because they've not found enough, but supposedly because they've found enough. But to some, it might not be enough. I get that. But in the Kenny Veach case, people won't know about this because it's a different thing, but you can check my channel for reference. The sister-in-law, Susan Veach, communicated with Las Vegas Metro Police Department about new findings, CCTV footage, 2018, Kenny caught on camera, and all of that. It gained the interest of the police. New police people were assigned to the case at the time, and it kind of opened up once again, active. So there was still that hope, there was still that chance. The same could happen here in Presgrove, a true crime related case, if you want to put it like that, because that's the branch it falls under, or at least in the community, in the niche. But for things to open up once again in activity, it needs a certain pull strong enough to get the attention. Whether that be someone coming forward, some kind of whistleblower, some kind of new shocking evidence found, physical, raw. But is it too late for that? Could there be any missing evidence lurking about in Oklahoma, in Terrell, in a stream, in a river, under a bridge, buried in the ground? Items like that. My question to you would be, if Noah's wallet was found all of a sudden, some passerby, some stranger, some person on the property found it and then handed it in, because the investigation has closed, if someone found new evidence in relation to Noah Presgrove or the case, would the investigation then open up to then allow and welcome it in to build that case? For a case to be built, there needs to be investigative material and evidence, but for evidence and material to be collected, there needs to be an investigation. You see a step-by-step process. Case is the big picture and everything inside it. So it's not completely all closed. But what else? If Noah's hat, if Noah's top, if Noah's Dalen's golf clubs, which Noah borrowed, the golf clubs were found now. Whether they're linked to the death or not, they went missing and so did other items. If all these items showed up now in bulk or one by one, would the OSBI open the investigation to allow that evidence in to be collected for the case of Noah, or would it not be welcomed? I want to know your thoughts on that. The chances of items like that now being found or collected, you could say, is hard to believe, but you never know. There's always twist. Just like how you've had those supposed witnesses and random and anonymous people online that have come forwards over the last few months all of a sudden stating what they saw or what someone else saw on the highway from the blue car to a naked person walking down the highway. Was any of that talked about or shared in the earlier days? From the looks of it, no. So why at a later point? Why now? In regard to that stuff, why now makes more sense, because if it's what people witnessed in the moment at the time leading up to Noah's death, that's in the moment. Back then, it was in the now. It should have been shared as soon as possible. If material and evidence shows up now, in the now, because it's only recently been found, it makes sense as to why it's taken this long, because it's been hidden all this time or no one knew of it, such as some of Noah's personal possessions, which were never collected or found, retrieved. But will the case become active? Will the investigation open for that? Exactly. So, yeah, interesting times. Hopefully it made sense to you, that analysis and interpretation. What we will move on to now is the plaintiff's response to a handful of defendants have claimed or wanted to be dismissed from the case, deny responsibility to Noah, and to be able to walk free and not look back on it again. Is that a sign of defense mechanism? Is it some sign of resistance? Or is it because they are genuinely confident that they have nothing to do with Noah's death? Well, let's find out in the papers. It reads, in the District Court of Stephens County, State of Oklahoma, the estate v. Avery Joe Howard, Carter Combs, Jack Newton, Caleb Newton, Johnny Trout Wilcoxon Jr., Stevie Howard, Logan Jernigan, John Jane Doe's A to Z of El Patrol. Out of the actual named individuals, who are the ones that are denying responsibility? I think that says it lower down. This was January? Is that January the 3rd or January the 30th? I can see like a 0, but I don't know if that's a misprint or not. But, it's kind of recent anyway. Let's see what's mentioned down here. The plaintiff's response to defendants Stevie Howard, Avery Howard, Carter Combs, and Logan Jernigan's motions to dismiss. Right, so does that come as a shock to people, as in who wants to be dismissed or for responsibility to be denied in some way? I mean, when it comes to Stevie Howard, trying to make sense of them because they weren't a party goer, because they were nowhere near the party when it happened, that's one excuse or response you could say. I believe the original point on the wrongful death lawsuit stated that Stevie Howard did know about the party taking place, before it even happened. So the responsibility of, if Stevie Howard knew of the party taking place, they would have known about the alcohol and known about who was attending, supposedly. So then the responsibility falls there. They could have done more. They could have prevented it. They could have stopped it. They could have denied the presence of alcohol, or they could have called the party off. With owning or part of the property or area, look, it's happening on their land, it falls back on them in some way. I think that's how it comes across. And with being a parent as well, the mother to Carter and Avery could have done more as a form of safeguarding or protection. But the thing is, it depends, because there might be a party, there might be alcohol, but on the surface level, you've got Carter Combs, who may be underage at the time, but they were a designated driver. They weren't drinking alcohol at the time. Were they ever drinking alcohol, though, or were they always drinking water and juice? Logan Jernigan, the one that would have been drinking and underage. But Avery, the birthday girl, turning 22 at the time, of the correct, appropriate age to be drinking, no rules or laws broken there, even as the party host. But in terms of the inviting underage people, indirectly inviting, if you'd call it minors, because it's under 18, like Brealey and Georgia. Because what we've got to understand, from Avery's point of view, they posted a public party invite online to anyone and everyone So that means anyone could show up of the correct age or underage or significantly older. Now, was Stevie Howard aware of who was being invited? You know, is there an answer to that? Because that would be important. As for Avery, Carter and Logan, likely they knew who was coming and who they wanted to be at the party, which could involve underage people when it comes to the legal drinking age. So there is responsibility there to an extent. So for some of those said individuals to want the motions to be dismissed, you could say it's a little bit shocking in a way. It is shocking as well because I can't remember if it's all three of them. I know two of the names were mentioned collectively on one paper, and then there might have been a separate one. Correct me if I'm wrong, but Avery, Carter, Combs and Logan all denied of being party host at the party which they created, which they invited, which they lived at the time. Private place, a party, inviting people down, hosting it, but none of those names admit to hosting the party. So supposedly there was no party host at the party, which was being hosted by no one. It makes no sense whatsoever. So how can you be in a permission for things to be dismissed when, you're saying that no one hosted the party even though you lived there and created it? Are they in a position to be dismissed? Don't think so. Let's just continue. The plaintiff, the estate of Noah Presgrove, respectfully submits this response to defendants Logan Jernigan, Stevie Howard, Avery Howard, Carter Combs, motion to dismiss for failure to state a claim. In short, defendant's motion to dismiss should be denied for two reasons. First, the motion to dismiss is not compliant with Rule 4 motions, the rules of the District Courts of Oklahoma under Title 12. Second, without pointing to any alleged deficiency, plaintiff petition must be allowed to. It'll continue on to the next page. Right, so obviously, whilst I'm talking, I'm not looking down at the text there. I'm kind of looking into the screen as I'm, narrating with my additional thoughts, just so you know. Sometimes there might be stuff in text on screen or lower down which either explains the situation or goes into more detail. But yeah, the motion to dismiss for failure to state a claim. What claim? The claim of explaining why they need to be dismissed. They didn't give one, so it's not good enough. Maybe. Defendant's motion to dismiss should be denied for two reasons. First, it's not compliant with the rule of certain motions. And the second, without pointing to any alleged deficiency. Well, as in an appropriate reason to why you should be dismissed and it's not given. Let's check further details here for it to continue. The analysis before the court is not one of the factual analysis, but the legal merits which, through plaintiff's well-pled petition, are more than adequate to allow plaintiffs to continue with its claims. Accordingly, defendant's motion to dismiss must be denied and can be denied without hearing per Rule 4. Introduction. As the Oklahoma Supreme Court previously observed, it should be the duty of an attorney to endeavour to raise the standards of his profession rather than to lower its integrity and prestige. As it stands, defendants raise 0 alleged deficiencies for their motion to dismiss, and the motions failed to contain the required brief per Rule 4, meaning plaintiff has no way of knowing what alleged deficiencies defendant claim and therefore cannot submit an adequate brief and response. Accordingly, per the guidance of Rule 4, the court should deny defendants' motions to dismiss. Arguments and authorities, standard review. Oklahoma courts disfavour motions to dismiss the outlined in Darrow Integris Health. The purpose of a motion to dismiss is to test the law that governs the claim in litigation, not the underlying facts. Motion to dismiss for failure to state a claim shall not be granted unless it appears without a doubt that the plaintiff can prove no set of facts in support of the claim for relief. The court must take as true as all the challenged pleading allegations together with all reasonable inferences that may be drawn from them. A plaintiff is required neither to identify a specific theory of recovery nor to set out the correct remedy or relief to which he or they may be entitled. if relief is possible under any sets of facts. Move on to the next one, which can be established and is consistent with the allegations, and motion to dismiss should be denied. Rule 4 requires in a motion a party must specifically state the grounds therefore and a relief or order sought, even where the party relies on defects or deficiencies apparent on the face of the pleading motion or other instrument. There are exactly 11 motions that can be raised without filing an accompanying brief. These are motions for extension of time if the request is made before expiration of the time period originally prescribed or extended by previous orders. Motions to continue a hearing, pre-trial, conference or trial. I've heard about that back then in the Dylan Rounds case when there was motions left, right and centre. Motions to amend pleadings or file supplemental pleadings. Motions to appoint a guardian and, is that item or litem? Motions for physical or mental examinations, motions to add or substitute parties, motions to enter or vacate default judgments, motions to confirm sales, motions to stay proceedings, to enforce judgments, motions to shorten prescribed time period, and motions for scheduling conferences and other settings. Notably, a motion to dismiss is not within the allowed motions that do not require an accompanying brief rule. State that if the motion does not comply with the requirements of B and C above, the motion may be denied without a hearing. Let's get to the conclusion part. When reviewing the motion to dismiss with plaintiff's well-pled petition, the motion to dismiss must be denied as the motion fails to comply with the Rule 4. Proposed motion dismisses test of law, governs investigation, not underlying facts. Plaintiff's petition and requested relief is possible under this set of facts raised within. This motion to dismiss should be denied. This motion may be denied without a hearing in an effort for efficiency and to preserve judicial resources. Plaintiffs respectfully ask the court exercise its power granted under Rule 4 and deny this motion without hearing due to defendant's failure to be compliant in both motions. So you could say in a way it's not a good look for the defendants as they have failed to be compliant. And lastly, I think this was on another Facebook post in the comments section, but just to add on for additional context, I guess, Brenda had mentioned that 4 of the defendants' motion to dismiss has been denied. I apologise for the off-subject comment. I think this was to do with a different post, that's why. Edit. I apologise for the misleading comment. The truth is the plaintiffs filed a motion to deny dismissal of 4 of the defendants, which we've just read. The judge has yet to rule on it because it's only the plaintiff's response, the estate, no Presgrove, no his family, not what the judge thinks yet. Now, do you think the judge will agree with the plaintiff's response or the opposite? Let me know in the comment section. If we just move that aside now, as said, I was going to take a look at some of the recent comments from the last No Presgrove video that I did. I've got it set to the newest. This will be in regard to a theory-based video, the highway and the culvert, and Caden wording it from when they jumped one of them. So just see people's reactions and responses. It'll probably be brief or so. A person called Great Ovation says, it's a fact that people that injure animals have the predisposition for being psychotic serial killers. Nothing short of a noose is good for these scumbags. I mean, if you're killing animals for the fun of it and you enjoy it and get off from doing it and you're stimulated, yeah, it can be signs of being a possible serial killer in the making, like when they look back to well-known serial killers, some of them when they were childhood time and onwards, got a hold of animals, insects, and then maybe advanced to bigger things, pets, and did bad stuff to them and killed. So yeah, I get that, what Great Ovation is saying, but if that really is the case, anyone that kills, injure animals in reckless ways as well and gets off from it, who does that actually apply to then, Great Ovation? Because you had Caden Pressey, you had the victim Noah Presgrove, you had Jack, you had Brylan and Isaac. Are all of them psychotic serial killers, including the one that was killed or dead, Noah Presgrove later? Yeah. Depends how you look at it. It depends on who participated. Everyone could have participated in some way by being present in the moment for it, and even maybe joking or laughing when animals were being killed. So it's a tricky situation, but there can be times where just because someone is a victim or was a victim doesn't always make them a victim or doesn't excuse all their actions for the future. I'm just talking in general there, but it is a possibility. Despite what people may have gone through, it doesn't justify what they do next to someone else or to something else. You can't keep using the card of the past to excuse current actions. The past is important and should not be forgotten. It should always be acknowledged, for sure. The importance behind it, the effects, the impact. But the present and the future, change can be made, and can't keep, it sounds harsh, but can't keep using excuses because it's not fair. There's more to the picture. There's a bigger picture to it. In regard to Presgrove and this situation here, yeah, I guess what's being said here, this person may believe that there is foul play, there is murder, right? So anyone that was involved in injuring or killing animals could have been in the making, foreshadowing signs of what was going to happen next, doing bad stuff, inflicting pain onto something living and not really caring about it. So if you used to narrow it down, if it's not Noah, later when Noah's on the receiving end, that animal, not saying he is, but treated like one if there was foul play. Who's the other guys present? Caden? Well, he's not been accused. He's not a defendant. Jack, he is one. Brylan, Isaac, they're not defendants nor named, but Jack is. But I think in the early days, and it may have changed since, but in the early days, Justin Roy believed there was a chance that maybe Brylan Sweat assisted in the cover-up, the clean-up of Noah. I remember that. Anyway, we got +1, Justice for Noah, consistent, shout out to +1. We got Callas, it's good to see this channel is still active. Welcome, Callas, to the channel. I'm not sure how long you've been around for, but first time I've seen you. Yeah, I try to be active as much as possible. Keep things going, of course. And, even on the sideline, just the fact that, like this case and some others, the people that I've met along the way, people that have found my channel, that helps as well, as in staying active and keep on going, because it can be for them. My videos are for them, those people too. You know who you are. So we got John Sims. You know that you would have to move fast and probably 100 feet to run up and grade to jump a 4-foot ditch. I mean, as well, I think it was said with a diagram, but if you go fast enough on a flat road, you can kind of hover over a pothole if you go fast enough. If you go too slow, you will obviously go into it and it could cause some form of damage. When it comes to doing a jump, you need a bit of a ramp, a bit of a bump to go over to push you into the air. If you haven't really got that, or it's not as prominent, then you would need to go faster for some additional boost in a way. Carl, yes, looking at these two culverts by the side of the road, especially the two-tunnel one, how the hell are you going to jump it unless you're jumping towards the road? If you effed up, it would be disastrous. Yeah. But I think the culvert closest to the party house property, the entrance-exit way, is a bit more likely because you can jump it, but you don't have to completely clear it. You can jump it and you have to clear with a lot of distance covered. I think that one's more likely in my opinion because the angling of it, you can come down the highway heading north and then cross over the lane, find there's no traffic and go shoot right across. But depending on the speed as well, you'd have to brake because once you've got over the culvert and you're on that dirt road, then you're in parallel with those fence lines running down. So you might crash into them if you're not careful enough. We got Julie Beck. I liked and hyped your video. So happy to see you. Warlike Raf covering Noah's case and keeping it alive. Appreciate that. Big shout out to Julie for still being here watching and, of course, hyping the video. If anyone wants to know what hyping a video means, it's just simply a tool that YouTube has implemented on this platform. If you're on mobile device or you're on a tablet, when you go down to the comment section, you should be able to scroll across, swipe across from comments to live chat to hype with a star. And if you hype the video gains points and it just ranks it a little bit higher on the platform, making the video more discoverable with better reach, meaning it might reach out to more people so then they can learn about the case and all the updates. So it has positive benefits to that. For the aspect of keeping the case alive, it goes a long way. And besides me keeping the case alive on YouTube, viewers can keep the case alive too, just by interacting with these videos in different ways. So it all helps. We got Tammy. Didn't one of the Spirit sessions mention something happened by the railroad tracks? That's a possibility, but not everybody believes in the spirit boxes. And, Tim Daniel, where you at, Tim Daniel? Get that spirit box out right now. What does the spirit box say? Tim Daniel is under an alias. His real name is, what? Is his first name Jack? Oh, no. Jack Daniels? Tim? Jack? Tim? What's going on? I think the spirit box is malfunctioning because someone spilled alcohol all over the device. It's not even working. Like an electric shock right now. Right through the body, man. Lightning. Anyway, let's move on. Dakota. Here we go. More dicking around. Any dicking about appears to be you with your petty default profile picture and lack of contribution to the case. Dakota. Yeah, let's move on. Carl. Hey, Warlike Ref. I disagree that Noah and the boys were reckless in the gun shooting here. In, North California, there's a lot of legal gun owners for hunting, and in legal Oklahoma, let's give a second. Oklahoma too. Unless they were really drunk, then it could be dangerous for sure. But I'm sure when we looked at social hosting, the rules and all that being broken, if you're in possession of a firearm and you're drunk, regardless of how drunk, if you're drunk and in possession of a firearm, there are problems. For sure. Yeah. Anyway. Also, in the pictures of the two street side views of the culverts, one would have to be driving pretty fast to jump. It also looks hard for me. The only way to jump them would be towards the road with the two tunnel culverts and away from the road. Oh, you said that in either comment, yeah. By the way, I looked up the law. If they were shooting at animals on the side of a public road right of way or railroad right of the way, it is illegal. Well, yeah. Also, to leave carcasses is illegal. On private property, it is okay. No one can use a land, motor vehicle, water vehicle, or aircraft. Right. And what you mean? No one can use a land, motor vehicle? What? Oh. What else do we have? Paul, just for your information, you never know when you might want to come here to shoot feral hogs from a helicopter. You can shoot feral hogs from a helicopter in Oklahoma with a permit. If on private property, you must have the okay from the property owner. Do you live in that area? Paula says, yes, I live in Oklahoma. I was actually born in Comanche, the same town Noah lived and went to school. So, Paula, do you have any inside information or knowledge with the case to community as what's gone on? If you do, feel free to reach out or share. What's your theory of what happened? Paula, I have mixed emotions about it. I do believe his body was staged on the highway. I do not believe he was hit by a vehicle just passing by. I strongly feel Noah was critically injured somewhere on that property, then placed on the highway. By who? I think there were several that were involved and more than several that know exactly what happened to him. I pray this gets settled soon so all this bickering will stop and Noah's loved ones don't have to keep playing through their minds what could have happened to him and who did what. Okay, interesting. And last but not least, Carl. And probably the only person that thinks Chris Pyatt might have hit Noah I think, how could Ellie clear him 100%? If he clipped Noah or ran over his body lying down, there'd be no evidence on the car except possibly a tiny amount of blood. I think Ellie's analysis was that they were working on the probability he was hit standing up. That would have left damage to the front bumper and car and maybe left debris at the scene, but just a clip of his head or run over, mostly with a tyre, it would not leave any evidence, in my opinion, right? No shade or blame to whoever. Oh, Chris Pyatt. George Choden responds and says, a little bit interesting, unrelated facts. In January of 2024, Chris Pyatt racked up a speeding ticket. Sort of excessive speed, more than 25 miles per hour over. No wonder OHP might have been interested in rechecking his vehicle. So, George, what's your stance on the situation? George, do you have your suspicions that maybe Chris Pyatt is involved in the death of Noah, or what? Oh, we got Ajax. Not seen them for a while. Welcome. Ellie followed no standardised or recognised acceptable CSI procedure. It's pretty obvious what's transpired, even by the time numbers used as code for Unity. It's a typical rich locals, remote local, Ellie all above. Presgrove wasn't in the club. This was a simple investigation that should have been closed out in a week. Tells you everything you need to know. Wow, that's interesting. 25 miles over the speed limit is pretty bad. Thanks for responding. Interesting. It's an interesting thing to look at those comments there, especially with what George added on too. So the actual event that Chris Pyatt was supposedly involved in of 2024 isn't directly linked to the Noah Presgrove case, but the theme of excessive speeding, 25 miles per hour more over whatever the speed limit was, is quite shocking. More shocking if it was on a certain style of road where the speed limit was naturally lower. On a highway, not as shocking, but still, it's bad. I believe what George is implying or suggesting that if Chris can speed so excessively and possibly recklessly, the faster you go, the higher the chances of something going wrong. The faster you go, the harder it is to stop quicker. So, or the higher the chances that when you're speeding, you could lose control of your vehicle for whatever reason. So when you, or if you link it back to when Chris Pyatt was on the 81 highway on the day of Noah's death and believed, he knew that he hit something, but he thought it could have been Noah after when hearing about the news of Noah. Maybe Chris was cleared, but with George saying people need to recheck his vehicle, or there was an interest to recheck, has that already been done? And if it had or was, what was the final verdict there? But I can understand that little reference as in, if you're going faster, more chances of something going wrong, more chances of not being able to stop quick enough to prevent a bad event following. And also, the faster you go, if you hit something, the faster, the more force, the more impact, the more brutal it will be. If you're going 1 mile per hour and you hit someone, it's going to be a little tap. You go 60, 70, 80, big difference, life-changing for someone, maybe life-ending. So, what speed was Chris Pyatt going when going down the highway when he hit something? Was it 25 miles per hour over the already speed limit, or was he going at a normal speed on that occasion? Something worth considering here and there. I mean, beside what George is suggesting and his possible suspicions with Chris Pyatt, you do still have Alicia Lee, Caden Pressey's mom, in the past that said that you can't trust Chris Pyatt. He's one of the most, biggest liars in the community or in the area out there. So Alicia doesn't think highly of Chris Pyatt. Chris had a few words to say to Alicia in one of my videos in the comment section, if you remember. So there was unresolved tension, disagreements there. And now we've got this on top of everything else. So be sure to hit that like button, share the video, spread the awareness, and drop a comment down below to let me know what you think of this overall situation and those court documents. Do you think it's heading in the right direction, justice for Noah? Or do you feel that there is still many steps ahead and possible unexpected twists and turns? With all that, My name's Warlike Ref. Thanks for watching, and those who watch in the background, it's much appreciated. We'll leave it there for now. We'll see what happens next. Goodbye and good night.